I'm Deborah McPhee, Dean for the Graduate School of Social Service, and I have the privilege of welcoming you to Fordham University today and to today's very special and important gathering. I'm also proud to be a part of a profession and an institution that's dedicated to human rights and social justice here in our city, across the country, and around the globe. You know, at this critical moment in our country's history, to have today's gathering with so many participants and organizations that bring so much experience and expertise and a shared commitment to ensuring what is right and just. It is heartwarming. And, you know, no one group, I would say, no one group, profession, or institution can advance the mission alone. And it really is in partnership that we achieve great things. And partnership certainly made today possible with contributions from her Migrant Hub here at the Graduate School of Social Service, Catholic Charities of New York, the Fordham Law School Feerick Center for Social Justice, and the New York City Public Advocate, Office of Public Advocate. I want to thank everybody for the support that they have brought to this endeavor. It's really enabled us to convene such a distinguished and interdisciplinary group of change agents. And, you know, the collaboration is going to be the tool, I think, that will help us confront those that would divide us and those that would turn back the clock on the hard-won freedoms achieved by those that came before us. In the past 12 months, we have witnessed a dizzying onslaught of inhumane behavior. From the southern border to inner city, in small towns and neighborhoods that don't make the front page. Individuals and families are being stripped of their constitutional and human rights in ways that I would have thought unimaginable in my lifetime. I am particularly mystified and horrified when I hear people refer to these conditions as the new normal, as though somehow adaptation rather than outrage is an acceptable response. Well, being here with all of you today gives me a renewed sense of hope. So I thank you. We have in the room, we have lawyers, we have social workers, we have legal advocates, we have community organizers, we have immigrants, activists, students, and educators, all individually and collectively committed to confronting and fighting back and to creating solutions. And I say creating intentionally because solutions to this crisis will not be found. They will need to be built on strong coalitions, communities, and collaborations among all of you and all of your extended networks. So with that, I will, it is my next job and it is my honor to introduce a leader on the front lines of change, who embodies the mission that we all so value. Yeah, I need my glasses for this one. Mr. Jumaane D. Williams, public advocate for the city of New York. First generation Brooklynite of Grenadian heritage, public advocate Williams is a lifelong New Yorker, dedicated to systemic reform and social justice. A former city council member of the 45th District, he has led significant efforts in gun violence prevention and housing rights, including the creation of the city's crisis management system. A proud graduate of New York City Public Schools at Brooklyn College, Mr. Williams brings rich lived experience and a decade of legislative leadership in his role as leading voice for transparency and equity in city government. Please help me welcome to the podium, Mr. Jumaane D. Williams.
Thank you, Dean. Peace and blessings. Love and light to everybody. How you doing? Good? All right. Everybody take a breath. One more time. Let's make some time to breathe. Make sure you're still here. A lot of love in the room, which is good for these times that we're in. Thank you, Dean, for that introduction. Thank you to all the partners, Fordham, Migrant Hub, Catholic Charities, and everyone for helping make this happen. Everybody who's out here, I know, trying to figure out what you can do in a moment like this. So it's a difficult day in an impossible moment. I'm at least glad to be brought together with people who I know are committed to compassionate work. We have been, we have seen so many horrific actions perpetrated by this government, some of which you mentioned, the Dean, the abductions of countless people in their homes, in the streets, in Federal Plaza, and of course, we've seen death. Keith Porter, Renee Good, Alex Pretty, many more whose names are not often lifted up, but whose lives and humanities also matter. We have seen so much, we felt so much, and yet I know we have also seen so many people step up, do what they can with what they have, where they are, support those with less resources or greater need. And that comes from compassion and is inspirational. In the case of our guest today, it can also be instruction. Today, I'm excited for us to have a dialogue about how we can show up for our neighbors, fully aware of the potential consequences, and ready to stand with the people who face those consequences. Like some of our guests today. My version of this came in 2018 when I was arrested trying to block the unjust deportation of Bobby Ragbear. I went to trial, cleared of some charges, convicted of others. Most importantly, Bobby Ragbear is free and is citizen today here in the country. Today, in the second Trump administration, court and legal rights are being treated as a luxury many cannot access. I can't go any further without thanking Fabiola Mendieta Cuapo from my office. Fabiola is a leader of our office, inside of it and outside of it, who's been on the front lines every single day. I'm just so amazed about her lived experiences and the work she continues to do. Thank you so much. And I've been honored in those moments when I'm with her to be able to join her, supporting our immigrant neighbors at rallies, in the courthouse, in the streets with you today. Injustice anywhere is a threat to justice everywhere. And right now, our government is perpetuating injustices everywhere, from Minneapolis to New York City. I spent time in the courtrooms of 26 Federal Plaza witnessing what atrocities are being carried out there. But I'm not alone. Advocates, clergy, lawyers, elected officials, daily workers, in their lunch break are coming to these public courtrooms to witness and watch what's happening to our neighbors. Maybe another pair of eyes makes it just a little more difficult to anonymously abduct someone. Maybe another pair of lips speaking out afterwards will make it a difference. I have to believe that anyone who knows the specific, unsanitized truth of what's going on will join in the moral outrage against it, the moral obligation to stop it. So I invite New Yorkers to join us in these spaces, to use our privilege of documentation to aid the families and lives being destroyed. I have to credit the faith leaders, advocates, and comptroller who have shown up and seen the suffering again and again, and then work to stop it. It is scary. It has to be okay to feel fear, but we also need the courage to match it. Maurice Bishop from my family's homeland of Grenada cautioned that revolutionaries do not have the right to be cowards. We can't be afraid, but we need the courage to match it. So there are things to be feared, but there's also much reason to hope. And many of those reasons are gathered here today because we keep showing up instead of giving up. I think that's really important. And just a few more words as I finish. It is important I make sure that I talk to folks in communities that we learn the lessons. Too many communities that I was shocked by, I like to say, drank the orange Kool-Aid, thinking that it was just going to happen to other people. And in history, it never just happens to other people. So I'm really hoping we take a lesson of that. We have to get through all this only together. And that means you have to get through this with people you're uncomfortable with, because someone may be uncomfortable with you. And we cannot exaggerate what's going on. To remind folks, in Germany, deportation was the first solution. It wasn't the last solution. These are not exaggerations. People said we had Trump derangement syndrome, but it was actually Trump denial syndrome. That was the biggest concern. The first day of the inauguration of the first Trump, there were people telling me that myself and others who got arrested on day one we're doing too much too soon. We said, no, we have to resist from day one. And I really wish more people had done that because this was telegraphed. Or if you know a little bit about history, this is lock and step with the worst things that we've seen. The only thing preventing the worst that we've seen is some of the guardrails that Donald Trump is trying to knock down as much as possible. Just today, I think he sent out a meme with the Obamas with their faces on monkeys. This is the President of the United States on his official Twitter. All of these things are tied together. They are literally trying to frighten America in a way that we've seen in the past. It is very disheartening. But unfortunately, that is part of America. Sometimes folks say this is not America. Nah, this kind of is. At the same time, there's a better part of America, and this includes folks in this room. So that gives me a lot of hope because the folks in this room have made change before. You may change again. I always say we know the names in history. A lot of folks, but there are tens of thousands of people whose names we never know, who just did what they could, what they had, where they were. They could pray, so they prayed. They could sing, they could sing. They could make a sandwich. They came and bear witness. Whatever you can do, you have the ability to do. And this system that is based on bias, is based on these kind of concepts. We're not created by anybody in this room. We're not created by anyone alive today. So I don't want folks to feel sometimes they're being accused of something, which is just not true because we didn't create it. But we do have the ability to figure out what system my daughter's daughter is going to get. And so that's where we can stand in the gap and try to change the system. Lastly, I will say a quote, two quotes. One from Brazil, no one let go of it in his hands. We just got to hold on to it. And the last one I got from RuPaul, which surprised me. I'm not usually watching RuPaul. But they said something that has really helped me in the past year, which is it's okay to look at the darkness, just don't stare at it. So please take a moment to look away, enjoy your family, enjoy the sunshine. I don't know about the snow, it's time for it to go. But just know life is still going on. You have to fight. Please take a moment to love your friends, family. I appreciate you. Peace and blessing, love and light to everyone. Thank you.
Good morning. Thank you so much, Public Advocate. That was really special for us to hear from you. Good morning, everyone. My name is Kelly Agnew Barajas. I'm one of the co-directors of our Immigrant and Refugee Services Division at Catholic Charities, New York. Thank you to all the partners who helped to put this event together at the Feerick Center, Fordham, at the Graduate School of Social Services of Fordham. It's so special to have all these partners in one room, such an interdisciplinary and multi-sector crowd, as well as the Public Advocate's Office for your contributions. We're really blessed to be together in conversation, and this is how we keep connecting and keep moving forward, finding the joy in this community, but also figuring out how to keep putting our oar in the water and keep going ahead in whatever way possible. At our most vulnerable moments, we can all think of where we have been in vulnerable moments. We don't necessarily look for a great hero with a great gesture. We look for a helper, whoever is there to be in that moment with us and walk with us with small gestures of kindness. This brings me to Scott Warren's story. Scott Warren is a humanitarian, a geographer, and a longtime volunteer with a group in the Southwest called No Más Muertos, No More Deaths. And for years, he and along with the group, helped to leave water, food, medical aid, and other forms of assistance in the Sonoran Desert. Life-saving work that was rooted in the belief that all human life is sacred. So in 2018, Scott was arrested and prosecuted, and he'll share with us more of his story. For such compassionate acts, he faced prison time. And this was, at the time, a line that was being tested. And we see that line now, not only tested, but crossed and crossed again and pushed, and the line keeps moving. So that people who are offering mutual aid, support, in the same way that Scott did, offering something as simple as water, is now being criminalized, that people are being accused of criminal conspiracies. And as Mr. Williams mentioned, not only arrested, fired from their jobs, punished, but also killed. So we hope to spend this morning thinking about these issues and processing. I'm a social worker, so we have to all process together how we can work together across all of our different sectors and wherever we stand so that we can keep compassion at the center of our communal work and seek out justice. Please join me in welcoming Scott Warren. Thanks.
Well, thanks for having me here. I prepared some remarks, so I'll read them. It should come in just under 20 minutes. And let me know if you can't hear me. I can speak up or change that. But I'm from Arizona, from a small town, not from there, but I live in a town called Ajo, AJO, as in Spanish for garlic, about 40 miles north of the Mexico border in the Sonoran Desert part of Arizona. And thanks so much for having me here. Thanks to Fordham and Migrant Hub and Catholic Charities for bringing me out. And I'll be in the city through Monday. I'll do an event at Columbia on Monday as well. But otherwise, I'd love to connect with you, chat in person, or however that works out while I'm here, or even afterwards, so we can continue the conversation. I'll talk about largely the events that happened during the first Trump administration, at least in the context of Southern Arizona and some of my lived experience there. But I want to do a few different things, really, maybe 5 different areas to cover in the short amount of time that I have. Talk a little bit about the place that I live, some more context on that, Ajo. It is the people and land there, it's Atem, it's Don Atem and Hiajit Atem. And I want to say that, of course, I am going to use some terms, I'll reference some terms that are frankly dehumanizing and offensive and racist. But they are the language that's used by Border Patrol, that's used by the legal system, that's used in the context of my trial. And so I will just say those things, not to dwell on them, but to speak honestly about the kind of language that's being used, of course. And I reckon we'll try to cover kind of, I think it's about 5 areas of a little bit of Ajo context, the misdemeanor and felony charges that I faced and some other folks faced as well. The kinds of pretexts and justifications that Border Patrol was using at that time, which will come as no surprise in our times now. And then especially the harboring law, so-called harboring law, and the Religious Freedom Restoration Act, both which were essential in my cases. And then we'll offer some brief discussion of the outcome and some conclusion. How's that sound? Okay. For most of the 20th century, Ajo was a company town with an open pit copper mine and smelter. In 1917, the original settlement that was mostly indigenous Atem and Sonoran Mexican was obliterated by digging and blasting, and so the company began building 3 new separate and segregated town sites, one called American Town, another called Mexican Town, and a third called Indian Town, as in Native American indigenous. At that time, a handful of powerful copper companies operated mines across the Arizona-Mexico borderlands, like the one in Ajo, and they dominated regional, state, and local politics. And the most powerful of these companies arguably being the Phelps Dodge Corporation, whose overall corporate headquarters were located here in New York City, apparently at 40 Wall Street in Manhattan. PD, as everyone called the company, had a reputation for being aggressively anti-union. It orchestrated, among other events, the 1917 Bisbee deportation, in which 1,200 union members and supporters were rounded up at gunpoint and shipped out of Arizona in boxcars. The 1946 so-called labor naval skirmish, where the company ferried strikebreakers on boats from Brooklyn into a copper wire production plant in Elizabeth, New Jersey. And lastly, the Great Arizona Mine Strike of the 1980s, which resulted in the near total decertification of unions in Arizona's mines and the closure of a number of operations across that state. That 1980 strike PD's strike-breaking efforts and the subsequent closure of the Aho mine left that community hurt, wounded, and disoriented. And I share this context with you now as a way of course, connecting the past to the present and for the purposes of making a point. We go back to the 1980s, just before the closure of the mine, we would find about 1,200 people working in the Aho mine and smelter. This industrial mining operation eclipsed the tiny Border Patrol station that at that time had just recently been built on the outskirts of Aho. And this was the first time a permanent Border Patrol contingent had been stationed in Aho, and it accommodated about 10 agents. Copper mining ended, of course, and those 1,200 jobs were lost forever. But by the time I moved to Aho in 2013, the Border Patrol station had grown from about 10 agents in the 1980s to a force of over 500 agents. Combine that with all the other personnel, new infrastructure, and billions of dollars that were being spent on border security, it gave one the feeling that the old economy of the Arizona-Mexico borderland, dominated by Phillips Dodge and the other copper companies, had come to be replaced by a new economic model, one dominated by the corporations and government agencies heavily invested in border security. And of course, for all that is novel and different about this new economic model, there's a strong sense that the underlying dynamics and social relations of the new era are perhaps not all that different from the days of PD and the company town. But the 1990s was pivotal in the growth of this new border security industry nationally and in southern Arizona in particular. In 1994, Border Patrol adopted prevention through deterrence, a deliberate effort to push migrants into rugged and remote terrain as official strategy. The effect has been the deaths of thousands of migrants from exposure, thirst, and other injuries in remote areas along the border. In Arizona alone, there are now over 4,000 documented deaths since the policy was implemented. In response to this humanitarian crisis, civilian NGO groups formed to provide humanitarian aid, medical care, and search, rescue, and recovery in the Arizona borderlands and elsewhere. And when I moved to Aho in 2013, I got involved with some of these groups, such as No More Deaths and the Aho Samaritans. An area of particular concern to all at that time was the remote Growler Valley located west of Aho within the Cabeza Prieta National Wildlife Refuge. In 2017, we approached the refuge manager asking for permission to drive administrative roads and leave water in areas where people were dying. They wavered in their response, so we let them know that we would go ahead and do it anyway, which we did, and several volunteers, including me, were subsequently charged with misdemeanor offenses for these actions, the primary of which was the, quote, abandonment of property, for having left water jugs behind in the desert where people were dying of thirst. About that same time, Border Patrol agents, Aho Station's so-called disrupt unit, had begun surveilling a place called the barn. There's no farm animals at the barn, but it is just the local name for a property owned by the town's retired physician and used by No More Deaths and other humanitarian groups as a base camp. 2 agents had set up surveillance from adjacent public lands, and when they saw me talking with 2 men, whose names are Jose and Christian, they determined from 200 yards and through a spotting scoop that Jose and Christian were in the country illegally. The agents then led a convoy of Border Patrol and sheriff's vehicles onto the property and arrested all 3 of us, Jose and Christian for the crime of being in the country illegally, and me for the felony crime of, quote, harboring aliens, for having given Jose and Christian, in the words of those agents, food, water, beds, and clean clothes over the course of their 3-day stay at the barn. I suspect that in the case of the misdemeanor charges, that prosecutors chose the abandonment of property charge, likely due to the fact that No More Deaths had successfully defeated charges of littering brought against them for having left water on a different federal wildlife refuge in southern Arizona in 2007. In the case of the felony harboring charges, Border Patrol's stated reasons for surveilling the barn were impressively malleable and ever-shifting. They implied that they were responding to community members' concerns about migrant-related trash in the vicinity. Or maybe they were conducting some kind of search and rescue operation for missing migrants, though they could never produce a report or even a description of the missing people for whom they were supposedly searching. We charged that the surveillance and arrest were part of a targeted campaign against No More Deaths for its criticism of Border Patrol. Earlier on the day I was arrested, for instance, No More Deaths had released part 2 of its Disappeared report series that documented Border Patrol's harmful and risky enforcement practices, such as destroying humanitarian aid supplies left for migrants in the desert, among many other things. Through discovery, my pro bono lawyers and I learned more. Earlier in the day I was arrested, agents had in fact been made aware of the critical report and had discussed the fact that representatives of No More Deaths were going to appear in the local 10 o'clock news to discuss the destruction of humanitarian aid supplies. Oh, wow, that's awesome, texted Border Patrol agent John Rambo Marquez. Wonder who they are going to blame. Later in the day, it was agent John Rambo Marquez and agent Brendan Burns who set up surveillance of the barn. After seeing me, Jose, and Christian talking outside, Agent Burns sent a group text to a team of Border Patrol agents nicknamed Los Perros Bravos Part 3, declaring that there were, quote, tonks at the barn. For those who don't know, tonk is an old Border Patrol slang term for migrants. It describes the sound that one of those old oversized flashlights, like the kind that run on D-sized batteries, makes when you hit somebody over the head with it. Upon learning this, Agent Paulos Ballesteros texts back to the group, "What? Exclamation point, question mark, 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 exclamation point. Nice." Agent Marquez then responds, "Yep, you're going to be live soon." Ah. They then rushed the property aggressively and without a warning. When I immediately told the agents they were on private property, a humanitarian aid station, and that they had to leave, they all froze for a moment and glanced at one another. Then Agent Marquez said, and without confidence, I would add, "Well, this is a public driveway, and I'm just going to go and knock on the front door of the house." Later in court, they called the entire operation a, quote, knock and talk. Months later, in a motion to dismiss hearing on the fact that agents had obviously violated my constitutional Fourth Amendment rights, Agents Burns and Marquez suggested that, sure, they remembered the interaction in which I said the barn was private property, but no, they didn't really remember. Maybe they couldn't really hear at the time whether I had explicitly told them to leave or not. And a very chummy magistrate judge let their version of events stand as fact, and our motion was not granted. Legal scholars and experts reached out to us after word of the arrest spread and suggested to us that we might have a strong defense against both these misdemeanor charges and the felony harboring charges by using the Religious Freedom Restoration Act. The Department of Justice, at that time headed by Jeff Sessions, after all, had affirmed its commitment to aggressive immigration enforcement, including the use of the harboring law broadly against anyone helping migrants in any way. But it also announced a policy of deference to and respect for individual religious liberty. The Religious Freedom Restoration Act, or RFRA, or RFRA for short, was passed in 1993 with broad bipartisan support, though I must say that my lawyers and I, along with many in No More Deaths, were initially skeptical of the law, having associated it strongly with the 2014 Hobby Lobby ruling, in which that company used a RFRA claim to deny giving its employees contraceptive care. But RFRA functions essentially, and here I'll pause, I'm not a lawyer, I'm not a legal scholar, I speak as a defendant in my understanding, and so I expect to be corrected and have clarification for all of you in this room as I talk about the laws and the sort of navigation of them, but I'll continue. As I understand, RFRA functions essentially to add a burden to a prosecutor's case where a defendant's actions in breaking a law are religiously motivated. Religion here not being defined solely as organized religion, but is expansive enough to include various forms of spirituality and religious-like worldviews. My words. In a RFRA claim, prosecutors really shouldn't question the validity or truth of any particular religious belief or practice, nor should they question the centrality of a particular practice, i.e., especially a practice that may be at odds with the law, to the defendant's overall belief structure. Prosecutors, however, can and do challenge whether the beliefs actually rise to the level of traditional religious and not, say, a belief that is rooted in a political or philosophical worldview. and they can and do question whether the defendant is sincere in those beliefs. The court finds the defendant's beliefs are religious and sincere, and if the defendant's actions were religiously motivated, then prosecutors must show that they still have a compelling interest in prosecuting that defendant. And importantly, as I understand it, the argument that, well, hey, it's the law and the law applies to everybody is generally not considered a compelling government interest. And prosecutors then have to show have to show that the government, in pursuit of a goal like immigration enforcement, is pursuing the least restrictive means possible in achieving that goal by prosecuting the defendant for their religiously motivated practices. Now, the so-called harboring law is the broad legal framework that can punish those, U.S. citizen or otherwise, who aid or support migrants in some kind of way. Critically, prosecutors have to show that a defendant aiding or supporting migrants did so with the intent to avoid immigration enforcement and or violate the law. The harboring law is a product of the expansive 1952 McCarran-Walter Immigration Act, and contained within that larger act was the specific language that made it a federal felony to, quote, transport, shield, conceal, harbor, or encourage an alien to reside in the country. I think it important to speak for a minute about the context of the 1950s, of course, when this act was passed, when the harboring law was put on the books. This legislation was widely referred to, universally referred to as the, quote, wetback bill. It was passed during a period of renegotiations between the U.S. and Mexico on the Bracero program, which brought millions of Mexicans to the U.S. as official guest workers, which was also still a time of widespread employment of unauthorized workers from Mexico in agriculture industries, and at a time of a mass deportation campaign being carried out by the Border Patrol and led by a charismatic former military commander. Agriculture interests, especially those in the politically powerful states of California and Texas, were major players in the politics of this moment. And the Texans especially chafed at the idea of the federal government inserting itself into their employment practices through Bracero or a harboring law that, as written, could obviously potentially be applied against employers. And so that state's congressional delegation made sure the infamous Texas proviso was added to the language of the act. It read, quote, provided, however, that for the purposes of this section, employment, including the usual and normal practices incident to employment, shall not be deemed to constitute harboring. The Texas proviso stood for 34 years, though it was struck from the harboring law in 1986 with the passage of the Immigration Reform and Control Act, which also did institute for the first time employer sanctions. But despite this, I would argue that the spirit of the Texas proviso is alive and well, especially in agriculture and even apparently, especially within this current presidential administration. All this to say, had it not been No More Deaths, rather a sprawling farming conglomerate of politically powerful Republican Party donors, I suspect there would have been no issue with providing food, water, clean clothes, and beds to undocumented men, though, like those kinds of farming operations have a very good track record of providing basic human services and sanitation to their workers, undocumented or otherwise. All of the politics and obvious contradictions aside, at issue in the harboring law is less the particular kinds of actions taken, rather one's intent in taking those actions. In my case, the facts weren't really contested. The government, however, charged that giving food, water, beds, and clean clothes to Jose and Christian was done so with the intent of hiding them from Border Patrol and violating the law. After all, they tried to convince the jury, what other intent could one possibly have in doing something like that? We argued that the intent in doing so was humanitarian in an effort to prevent the death and suffering of people in the borderlands. So there's far more to say, of course, about how this all actually played out in court. But for the sake of time, I'll jump to the conclusion here. In the misdemeanor case, the abandonment of property case, we did use a RFRA defense, and we were successful with that. In the felony harboring case, we set up RFRA as a potential defense, but Ultimately, we did not use it. Instead, we argued, and the jury eventually came to unanimous agreement that the government had not proved that I had violated any law in giving Jose and Christian food, water, beds, and clean clothes, among other things, over the course of 3 days. Fair. But before I conclude here, I will just point out one additional factor that, had we used RFRA as a defense in the harboring case, probably would have even further strengthened our claim. I was just speaking about the former Texas proviso carve-out to the harboring law. But in 2005, a new amendment to the harboring law was made by Representative Bob Bennett of Utah. And we might be right to call this the so-called Utah proviso. Bob Bennett was a Republican and a member of the Church of Jesus Christ of Latter-day Saints. His work on this particular amendment was aggressively fought by immigration hardliners in the Republican Party at the time, especially Tom Tancredo of Colorado and others. And Bob Bennett was upset in a Tea Party primary in 2010. We all know the history there. But he did get his amendment passed, and its language specified that actions taken by religious organizations to take on and support undocumented people who work as volunteers or missionaries of a church would not constitute harboring. By way of conclusion, I'm standing here and talking to you today as a former defendant in these cases, but the community of those directly affected by these cases, those engaged in the defense, and those broadly in solidarity is vast and wide. It includes so many people, obviously my outstanding pro bono attorneys, and many others who volunteered their time and effort, and it especially includes Jose and Christian, the two young men from Central America arrested along with me. The government detained Jose and Christian for several weeks, and in exchange for their testimony, they were promised only a speedy deportation without criminal prosecution. In recorded depositions, prosecutors aggressively cut short any of their responses that began to shed light on the complex lived experiences of these two young men. Nevertheless, they talked about how they traveled across Mexico, navigated the desert between the border and Ajo on foot, and how they plan to continue walking northward. They talked about the need that drove them, which of course was to provide for their families and find safety from a multitude of threats in their home countries. And they talked about the relentless violence and exploitation that seemed to follow them everywhere along that journey. That's fine, prosecutors interrupted. But how did you know where to go? Who told you where to go? To that, Christian replied, "We researched the best way to go on my phone. I have a compass app that tells the direction. And at night, we found our way by the stars. We took care of each other." So, thanks, everybody.
Scott, thank you so much. Margaret Martin, I am the other co-director of the Division of Immigrant and Refugee Services at Catholic Charities in New York. So happy to see so many of you here. Thank you so much for coming. Huge thanks to the public advocate in his office for coming, and to Dean McPhee for being here, and all of our panelists. And Scott, months and months ago, Kelly and I were like, oh, we gotta get Scott out to the East Coast. People need to hear Scott's story. And then we're like, how? And our amazing friends and colleagues from Fordham stepped in and said, we've got this. Like, we will figure it out. So many thanks to them. And honestly, the unsung interns, without whom we would have no programs, probably no registration link. We would not see Emerson appearing on this screen shortly. They have just made our lives easier, and yours too, in measurable ways. Our panelists are all here, but for one who is joining us remotely, I think from his vacation. So he was we're just delighted to have him, and that's fine with us for him to join on vacation as long as he doesn't talk about it too much. But what a great time he's having, especially as we all suffer through the snow. I am delighted to introduce our four panelists who will be joined by Scott as well for Q&A. Together, they are going to address the overall environment that immigrants in the United States and those of us who serve them find themselves in this moment, and how radically different, as you've already heard a little bit from the public advocate and from Scott, it is in some ways from the modern history of immigration to the U.S. in some ways, and how the environment that Scott discussed of criminalizing compassion and flouting the rule of law has impacts across the system and in profoundly disruptive and disorienting ways to those who are caught up in it. I feel like I can't use the word shock enough in the last 13 months. Our panelists are going to reflect on what they're seeing in this last year and also historically. Although we have seen massive shifts since the beginning of 2025, it isn't as though the system hasn't been, in many ways, broken, ineffective, and arbitrary for many, many years, as Scott was talking about. And importantly, and perhaps most importantly, you'll also hear about the incredible resilience, heroism, and basic stick-to-itiveness of so many everyday heroes. I want to acknowledge the 5 special guests of the public advocate who are here today. I don't know if I can have the 5 of you stand up, but they're not going to be speaking on the panel. We probably should have had multiple panels, but they will be helping us lead the roundtables today. I'm so really grateful for those of you who are here with the public advocate. Okay. So I am not going to give long introductions of the panelists, but I encourage you to read in a very small print in the programs about each of them and their sort of amazing backgrounds and the experience they bring to this. So very briefly, I'll just go through who they are. Lisa Landau is the newish executive director of the Feerick Center for Social Justice at Fordham Law School. And has more than 35 years of deep experience across civil legal services, government, and the nonprofit sector. Lisa is going to give a sort of big picture overview, step back of the current environment of prosecution and punishment, sort of as an analog to what Scott was talking about from a humanitarian perspective. Carmen Maria Ricadas is currently the senior counsel at Co-Counsel, which is a nonprofit that partners with community organizations to address the legal needs of immigrant communities throughout New York City. She's also a supervising attorney in the Immigration Justice Clinic at Pace Law School. Most recently, Carmen served as an immigration judge with the Department of Justice, both in Georgia and at 26 Federal Plaza. And she's going to talk about her experience as a former immigration judge, but also a leader in the immigration legal space. Emerson Argueta, thank you very much for joining us remotely. So happy to have you, is the Associate Director of the Feerick Center, so he works with Lisa. Emerson is both an academic and also has been a practitioner and continues working with communities. And so he's going to talk about how we got here and the impacts that he has seen on communities and institutions, including academia, more broadly. And then last but certainly not least, Nurka Melendez is the co-founder of Venezuelans and Immigrants Aid in New York City, which provides support, resources, and advocacy for asylum seekers and other displaced people, helping them to navigate complex systems and fostering community integration. She also has a day job that occupies her the rest of her time. New York is going to talk specifically about the asylum process, her lived experience, and what her community is experiencing now and the considerations that are entering into their life choices. And it is such a pleasure and honor to be sitting up here with these panelists. So I'm gonna kick it over to Lisa. Let's start with you and sort of the big picture overview.
Sure. Let me it's working. Good. Thank you so much. And thank you for including the Feerick Center for Social Justice in this important convening. And I am going to try to zoom back a bit after Scott's incredible discussion of his own experience with the legal system and really talk about sanctuary, as a part of our community thinking and the ways that governments actually have passed sanctuary laws and the fate of those. So in thinking about the theme of today's panel, I'm struck by how much decency, goodness, and care have been in the crosshairs of the current administration, whether it's actually criminalizing with a big C or criminalizing with a small c. And I'm sure many of you have heard the words fire hose to describe the myriad of efforts coming at all of us individually and communally, fast and furious, and many of these efforts aiming to extinguish existing systems. And that holds true for both legal systems and humanitarian systems. And legal systems are based on humanitarian principles. So this morning, I'm first going to turn to the administration's broad attack on sanctuary cities and states' laws. And then I'll briefly talk about the administration's targeting a judge in Milwaukee and a congresswoman in New Jersey. All of these examples demonstrate the criminalization of compassion in vivid and disturbing ways and provide a continuing call to action for all of us. So one of the early efforts to attack legal systems based on humanitarian principles is the administration's legal challenges against sanctuary city and state legislation. To quickly explain, because I know not everyone here is a lawyer, and I think most may not be, but we all understand these basic concepts. Sanctuary policies are regulations or laws adopted by state and or local governments that set out that these governments will not aid or assist federal officials in enforcing particular types of federal laws, including and importantly, immigration laws. So over the past decades, numerous sanctuary cities and sanctuary states have adopted policies barring their law enforcement agencies from assisting in the deportation of many categories of undocumented immigrants, and usually those not convicted of serious crimes. New York City sanctuary laws, here we are in New York City, include not using city resources for federal immigration enforcement and limiting access by non-city personnel like ICE to non-public areas of city property without a judicial warrant. So the current administration has claimed that sanctuary laws are obstructionist and interfere with federal law enforcement efforts. But to be clear, these sanctuary policies are not able to protect people necessarily. They're not creating sanctuaries for individuals. They're really focused on barring assistance to the federal authorities. And so launching right into the attacks, the Department of Justice sued Illinois and the city of Chicago back in February 2025, so very early in the administration. And then in April, the administration issued 2 executive orders specifically targeting sanctuary cities and states. And just to note, executive orders don't have the force of law, but they do set out a roadmap and directives to agencies, which may not have a lawful basis. And in this instance, the first executive order is called Protecting American Communities from Criminal Aliens and directs the Department of Justice and the Department of Homeland Security to prosecute state or local officials who refuse to assist with the administration's deportation plans. And the second one, issued on the same day, titled Strengthening and Unleashing America's Law Enforcement to Pursue Criminals and Protect Innocent Citizens. And that one directs law enforcement to pursue legal action against state officials, seeks to prevent accountability for law enforcement misconduct, and encourages police brutality. The executive orders targeted the Justice Department to write out a list of jurisdictions to be targeted. And since then, the Justice Department has filed lawsuits against cities and states for implementing policies that limit cooperation with immigration authorities. In 2025, the Justice Department separately filed lawsuits against state and cities, including New York City, New York State, the city of Rochester, 4 cities in New Jersey, Colorado, Los Angeles, Illinois, New Jersey. The lawsuits target immigration-friendly policies, arguing, again, that these initiatives violate federal immigration laws. Just to say, these cases have largely been dismissed, but some are still percolating up through the appeals courts. And the cases haven't succeeded because of a couple of basic principles. One is the 10th Amendment that says that the federal government can't commandeer state and localities with federal law and interfere with state and local autonomy. And the other is that federal immigration laws don't take precedence. They don't preempt these laws because these state laws are not directly inconsistent with federal laws, the immigration laws. And so, just turning to a very strong decision, dismissing the federal case against New York State, I wanted to just mention there's a very specific law in New York called the Protect Our Courts Act, POCA, passed in 2020, importantly, codifying a longstanding privilege of protecting parties and witnesses from civil arrests in courthouses and while traveling to and from court proceedings. And these are state and local courthouses, just to say. And ICE's own old directives, 2012, urged discretion in conducting enforcement activities, expressly acknowledging the potential that these kinds of activities can deter individuals from reporting crimes and from pursuing actions to protect their civil rights, right? Going into courthouses and frightening people from availing themselves of their right to be in court, to assert their own rights. And so this actually turns me to, and for all of you, a particular specific prosecution that took place in Milwaukee just this past year, and you may have read a little bit about it. So it's Judge Hannah Dugan in Milwaukee, a Milwaukee State Court judge. The administration's aim at sanctuary laws and POCA, the law I just quickly described, really brings us to focus on Hannah Dugan, who allegedly let someone who was appearing before her on a misdemeanor criminal charge out of her courtroom to a back staircase that did lead to a public hallway, just to say, while she sent ICE agents who were stationed outside her courtroom to the chief judge's office in the building. And I want to just note for a moment, Judge Dugan spent most of her career working at legal services organizations and served as executive director of Catholic Charities of southeastern Wisconsin before becoming a judge. In 2016, Judge Dugan was elected as a state court, circuit court judge, and primarily it was overseeing the misdemeanor division. And so after this incident in her courtroom, she was arrested a week later by the FBI and charged with federal obstruction. Supporters immediately emerged. In May 2025, over 150 former federal and state judges, along with legal experts, signed letters and an amicus brief supporting Judge Dugan, condemning her April 2025 arrest by federal agents as an authoritarian attack on judicial independence and an effort to intimidate the judiciary. These officials argued that her actions in the courtroom were protected by judicial immunity and that the prosecution was a retaliatory, politically motivated move. But just on December 18th, so just 2 months ago, Judge Dugan was convicted of a felony charge, impeding a proceeding, and found not guilty of a misdemeanor charge of helping an undocumented immigrant evade ICE agents. So it's a split verdict, puzzling a little, but these things happen because of juries. Some elements of one charge against Judge Dugan are the same as the elements needed to prove the other. And so just last week, on January 30th, these issues being very alive, Judge Dugan moved for a new trial and for a judgment of acquittal. And we're going to have to wait to see what happens. I want to read, though, a piece of her resignation letter, because the judge felt that this was not a situation that she wanted to impose on the people of Wisconsin and the people in her community in Milwaukee. I have presided over thousands and thousands of cases with a commitment to treat all persons with dignity and respect, to act justly, deliberatively, and consistently, and to maintain a courtroom with the decorum and safety the public deserves. She further writes that she will continue fighting this conviction for herself as well as for the independent judiciary, but that she wishes that Wisconsin citizens start the year with a judge on the bench rather than have the fate of that court rest in a partisan fight in the state legislature. So very, very brave and impressive example of a person here, a state court judge, doing her job as a judge and acting with compassion to a defendant before her, and what's been her fate since that time. So I'm lastly going to turn to LaMonica McIver, a congresswoman from New Jersey's 10th district, so close by. She's been a congresswoman since September of 2024 and is a person who grew up in the area in public housing, is the first Black person to have the Congress seat in that area. And so what happened to Representative McIver is that she went to make an oversight visit to an ICE detention facility in Newark, which is her job as a representative and her right as a representative of the people. And she went alongside with two other Democrats to look at conditions and understanding that conditions were dire in that facility that had been transferred to a private corporation not long before that was running the show there. She came with the mayor of Newark, who apparently was believed not to be able to come onto the premises, and he was arrested. The representatives were trying to protect him, and the ICE agents essentially were asserting that she assaulted them, and there are competing video accounts that show that this isn't the case. In any case, the representative was indicted a month later by the U.S. attorney, who has now been basically fired from her position that she wasn't authorized to have, and she awaits prosecution, more prosecution, and she faces years in prison for this action. I want to just mention that a few members of Congress, after this happened, issued a press release and a letter demanding that DHS and ICE issue a directive that under current law, members of Congress have a legal right to show up, which they do under federal law, under the appropriations law. And just to say, a lawsuit was filed in the summertime by a dozen members of the House of Representatives in D.C., and the decision has come out from the D.C. Circuit or D.C. District Court that asserts and rules that, at least as a preliminary matter, that there is no 7-day notice that ICE had been requiring before representatives come, and that they have a right to be there to observe what's happening in these detention facilities. So just to say that the pursuit of the judge and the representative McIver is part of a pattern of federal targeting of Democratic office holders, including Jerry Nadler, Alex Padilla, Brad Lander, and 6 people in Chicago in October. All of these people who are representing our communities, doing their work to enforce the law on behalf of all of us. So just in closing, we see so many versions of kindness, compassion, community being the subject of federal attacks on all levels, on state and local governments, on judges, on legislators, specifically to target legal activities that are rooted in love and compassion, activities that themselves are the very examples of how we take care of each other. In the face of these attacks, we must be undaunted and continue as individuals and as communities to exercise kindness and compassion. It is our moral and humanitarian duty to do so. So thank you.
Thank you. Thank you, Lisa. I want to pull a thread that you were sort of talking about, because I think it segues really nicely to Carmen, which is you were talking about frightening people from going to courthouses. And you weren't talking about immigration courts necessarily, but I think that's something that we've sort of seen a lot of in the last year. And so as a former immigration judge and also immigration practitioner for many years, I'm going to turn it to Carmen now. Thank you. Also, I don't, for Emerson, when we get to you, Kate is holding up a little sign to give people, I think, a 1-minute warning, but I don't know if you're going to be able to see it. So if you can't, I might just rudely interrupt you if you're running way over, okay?
We can text him.
We can text you.
him.
We'll use technology. Great, thank you.
So is Lisa answering that question?
No, I'm turning it over to
you're
you.
turning it over to me. Okay.
Segue.
Unlike Lisa, I am more of an off-the-cuff speaker after decades of just talking. This is what I do. So I'm Carmen, and I'd like to talk a little bit about today a couple of things. I don't know how knowledgeable everyone is in the room about the immigration system in the United States. So I'm going to talk a little bit about that because I think it helps to kind of to give an understanding of why so many of us have been now for decades ringing bells saying this is a path that we're on. This is frightening for everybody. We need to put an end to it. And we're now once again, I would say, similarly to the way we were kind of feeling during the first administration, we are now in panic mode. But for many of us that have been working within immigration systems for decades, this was foretold. We knew we were going to end up here, just because of the pattern that we've been seeing develop over the last 30 years. So I want to talk a little bit about that. And I want to talk a little bit about this kind of shifting of goalposts of what it means to be an American that we're seeing play out and the use of the legal system and the weaponization of the legal system. And then hopefully I'll close with just a little bit of what I see personally as my path forward, which hopefully we can kind of all keep perhaps as a little bit of a thought, because we are in a battle that is not going to end today. So I am not U.S. born. I was brought to the United States as an early teenager by my parents, who had come to the United States about 8 years before. And I hadn't seen them during that time. They were economic migrants from Spain, which at the time, I know now is everyone's favorite tourist destination. At the time, it was a country where fascism had just ended after a very successful 40 years, during which the Spanish left, of which my family were part, had been forced to either shut up and withstand or leave. And the majority of my family had left. My mother had been one of the people that had stayed behind. She was one of the youngest in her family. And then when the economy, the bottom fell out under the economy, she and my father came, left me behind, as many of our clients now do. And so I was brought here. We were undocumented for a bit, but there was a path forward because at the time, kind of the end of the Reagan amnesty. And I am one of the last beneficiaries of a humane immigration system. And it wasn't even humane then, but I came in the early 90s. And it is important for us all to center that we are in a period of immigrant backlash. But that period has been going on since at the very least 1996, when we passed as a country under Bill Clinton, IRERA, or IRA, as others call it. And IRA re-envisioned immigration as being akin to criminal law and really created a massively expanded immigration civil detention and created these incredibly harsh punishments for immigrants who had any contact whatsoever with systems, with legal systems, especially the criminal system, but not only the criminal system. For example, after 1996, the law went into effect in 1997, so we usually call it the 1997 IRERA, but it was passed in 1996. And in 1996, Congress said, you know what? It doesn't matter to us if you're a lawful permanent resident of the United States. And you've been here for 40 years, and this is really the only country you know. We will make you deportable from this country if you have an order of protection against you. Now, we all know that that we all are familiar with systems. We know how low the standard is for an order of protection. And having an order of protection against you could potentially ruin your entire life and get you banished to a country to which you have no ties. And I would argue, as someone who worked for a long time in violence, in domestic violence specifically, and gender-based violence more broadly, that this kind of criminalization, this punishment lens that we put on immigration in 1997 solidifies and strengthens the idea that immigrants are different from us, that immigrants are somehow criminal, even though the statistics don't show that, and that Americans get to exercise power over immigrants by calling authorities, at the time INS, and later in the early 2000s, ICE. I worked for a long time in domestic violence. We were aware of it even back then because this was happening line in line with Americans bringing in foreign wives. It was the time of Americans going abroad, obtaining women abroad and bringing them back into the country, and then holding them, binding them to abusive relationships by virtue of preventing them from obtaining immigration status and then being subject to deportation. And I was one of the people that were working on expanding the law to recognize the inherent power and control dynamic in immigration and disrupting that power and control dynamic. And the first time I got a death threat was on an online chat thing that used to exist back in the old days from old American men who were very upset at this upstart immigrant in New York who was telling women how to fight back and get themselves green cards and tell their husbands to go. I was 25 years old and I was amazed. I thought to myself, well, this can't possibly be true. It can't possibly be that there are any people that see this as a thing that is right. I was so morally sure that if Americans just understood what the problem was in immigration law, that we would all get together and fix it. And I have been upset year after year after year because all I've seen through Democratic and Republican alike is an even further expansion of immigration detention, an even further calcification of this stupid rhetoric of immigrants are criminals, and a furthering of an expansion of federal power under the guise of immigration enforcement. During the first Trump administration, I, who speak off the cuff without prepared remarks and so often say things that perhaps I should not say publicly, was on an interview on New York One where I was asked to give some general legal advice to New Yorkers who were foreign-born, who may confront immigration authorities at their front step. And at the time, we were in a period, as we are now, where ICE was showing up and knocking on doors and asking to be allowed in. And if you let them in, you were done. Your Fourth Amendment right to have privacy of your own home and not have law enforcement enter your home was waived. And so the advice that we were giving, which continues to be correct under the law, is you say no. Unless someone has a judicial warrant, you say no. You don't let someone into your home if you don't want them to be there. And even if they have a judicial warrant, all that means is that they can break your door down. And I may or may not have said, listen, if you're worried about your well-being, let them break the door down. It will cost you less to replace the door if they have a judicial warrant. And if they don't have a judicial warrant, you can be sure that they go away because they don't have a right to break into your home. And that advice, which is rooted in constitutional law, was later used by certain members of the Republican Party to call for me being fired as a judge because I had shown animus against ICE. It is not animus towards a law enforcement agency to hold them accountable to the same laws that I would hold NYPD accountable, that I would hold FBI accountable, that we as a community would hold any of us accountable. We are all accountable to the law. That has, unfortunately, that notion has been eroded in the context of immigration. As you all should know, the Sixth Amendment to the Constitution imbues all of us who are American citizens, either by birth or by derivation or by naturalization, with the right to certain protections when charged criminally. Those rights do not extend to us if, or at least the Supreme Court has never extended them to us, if we are charged civilly. So you do not get a right to counsel if you're charged with a civil offense. You do not get a right to certain standards of prison standards if you are detained under civil authority. Nor does anyone appoint you an attorney if they're accusing you of violating a civil law. Immigration is only civil, and yet being detained in immigration results in your permanent banishment from the United States, separation from family for the entirety of your life, an utter loss of means of self-supporting, potentially death if you are deported to the wrong country. And increasingly, although this really has been the case since IRERA back in 1996, long-term detention, sometimes lasting years, in conditions that are so bad that they would not pass muster if you were being charged with murder and detained in those conditions. Reports consistently show that civil detention costs civil detention companies, which detain the majority of immigrants in the United States, about 80 cents a day in food. 80 cents a day in food. They're making an average of $150 a day for every bed they fill. If you tell me that this is not a fight for money, I will tell you that you are not reading the room. This is about how much money can we make on the backs of immigrants, the same way that the need for Reconstruction, for the 13th and 14th Amendment had to do with how much money could be exploited from slaves in this country, from chattel slavery. And so the fight against it must be very, very kind of clear in that we are fighting against the idea that people's rights and decency and humanity is up for sale. All right, now with all of that being said, so I've done all kinds of stuff in my career, all centered around immigration, because even back when I was a baby lawyer, I kind of had the realization after having worked with migrant communities in other parts of the world that migration was the human rights issue of our era. We have, I think, at last count, and I haven't looked in about 6 months, we had an excess of 86 million people who were forced migrants around the world. And that population is largely in many parts of the world without rights whatsoever. In many parts of the world, they are given a temporary ability to live, but they are not given citizenship. They're not given a path to permanence. And I thought, as a baby lawyer, that permanence matters to people. Permanence mattered to me. The U.S. may not have welcomed me at first, but it came to welcome me. It gave me permanence. I felt American. I eventually became a citizen. I felt I could fight for something. I could make this country reflect my values. It matters to people. And that concept of permanence has been really central in the United States immigration laws. It has been historically the fact that we may have restrained migration in, but once you were in and you had ties here, we generally put you on a path, with some exceptions, to eventual citizenship, which meant that you would one day potentially be American and your children certainly would be American. That is now at play now. Not since 1865 has that been at play. We thought it was long settled. The first time I saw the executive order, I laughed. Executive orders can't change the Constitution, I thought, because clearly I am not a constitutional scholar and I am not aware of fringe arguments otherwise. And I'm running out of time. And this is why you prepare remarks. The notion of who can be an American is at play, because suddenly, once again, we are questioning whether people who are foreign-born can become Americans at all by reinterpreting our immigration laws, by creating additional roadblocks to obtaining citizenship. by determining suddenly that people who are born of foreign citizens can potentially no longer be Americans by birth. But we are also, by virtue of this very clear cruelty that has been building up in the last 30 years, questioning what it means to be an American, even if we are Americans. Everyone in this room, by virtue of being in this room, I think I can assume, holds certain parts of the Declaration of Independence very close to their hearts. That all people are created equal. That's editorializing. It was all men, but all people are created equal. And we are all imbued by whatever authority you believe with certain inalienable rights. That theory of who can be an American, that has defined who can be an American really since 1865, when we finalized the Civil War, is now again at play. And there are certain parts of this country that would say that our law should limit who can be an American, not to people who abide by this ideology that united us all for over 100 years, but rather by what we look like and where our parents came from. And I would say, no, the buck stops with us. And in that, I take great comfort from the fight for civil rights. People who were brought here against their will as chattel slaves fought for hundreds of years for recognition as even being people. And they did so with allies, putting their bodies on the line, but they also did it for themselves. In that, the fight for immigrant rights is equivalent and much like the fight for civil rights for Black Americans. We are in a period of retrenchment. But much like the fight for civil rights, there is a future. And our goal for the next 3 years has to be, how do we look past this period when we are being forced to recognize what is being done by people we don't agree with putatively in our name, to a future where we once again recognize that it is our shared inalienable rights and our vision for this country that unite us as Americans. And in that, I would say to actually think globally, to Nelson Mandela. When I sat on the bench, I had a quote from Nelson Mandela on my desk. And any time I had to decide a case, and I denied a lot of cases because the law is not friendly. Our immigration laws need rewriting. They are inhumane. And my job was to apply them. I denied a lot of cases, but I also granted a lot of cases. And I looked to this quote every time I denied a case and every time I granted a case. And the quote is this: "For to be free is not merely to cast off one's chains, but to live in a way that respects and enhances the freedom of others." And that is our responsibility as American citizens and Americans. We must continue to fight to uphold the freedoms of all people in the United States. And for that, I'm going to shush. I'm out of trouble.
Beautiful. Thank you, Carmen. Hallelujah. Thank you. Thank you, Carmen. Really appreciate that. I love that quote. Please email it to me. But first, I want to turn it over to Emerson. You are the biggest head in the room, Emerson. Emerson, we really want to hear about your perspective, both as an immigration lawyer, but also now within academics, and sort of your perspective on these issues today.
Sure. Thank you. And thank you to Marciana at her Migrant Hub, to the Graduate School of Social Services, Catholic Charities, the Office of the Public Advocate. It's really an honor to be part of this conversation, and I will do my best to stay within time. I also want to begin by just sharing a little bit about my own personal history, because this is how I have come to understand the community that we serve. I am myself a foreign-born former asylum seeker from El Salvador. And I was lucky that my family arrived in the United States before IRIRA, because had we arrived after 1997, as Carmen pointed out, my mother and I, my father and my older brother, would have been detained in a family detention center, potentially. Much like we've seen the blue bunny ear-hatted little boy from Minneapolis. And so, it's not lost on me the privilege that I have and the trajectory that I was able to enjoy to be able to do this work now. I'm not going to take you down too much of what expedited removal means, but this was one of the changes under the law. And essentially, what expedited removal allowed, one of the things, is that it enabled Border Patrol agents to be gatekeepers and be the ones in charge of asking whether somebody feared return to their home country. And if a person was not able to articulate a fear of return to their home country, to then gain access to a preliminary interview to see if you would be let into the country, then you are subject to, as the word says, expedited removal, just deported summarily without an opportunity before a judge. Glad to be here, my dog in the background. And so, a lot of what the Feerick Center did is, and when I was a student, to go down, give me a moment. Sorry about that. A lot of the work that the Feerick Center did and that I enjoyed the opportunity to join was going to the detention facilities and interviewing folks who were recently arrived seeking humanitarian protections in the form of asylum. And access to legal counsel is so critical. And this is another area that is under assault right now. And when the rhetoric began in the first Trump administration about dirty immigration lawyers, accusing folks of coaching their clients to invent facts, all of that was laying the groundwork for what we're seeing today. I grew up on Long Island, and I remember that in the first Trump administration, Jeff Sessions, gave a speech at the Suffolk County Police Department, sort of touting the targeting of MS-13 gang members. And that is a situation that I understood very closely because, when I was graduating law school, I was thinking of what kind of a project I could do as a fellowship. And I learned about this school to prison pipeline, this reality that on Long Island, especially in Suffolk County, there were accusations, many times totally bogus or frankly racially motivated accusations about, teenage asylum seekers or eligible for other forms of relief for unaccompanied children being labeled gang members just because of, the drawings on their notebooks or their associations or their form of dress. And that is actually a legal process that would end up potentially in them being placed in immigration detention. And you heard what Carmen described about what those conditions are like, and so all of this, is something that we are now seeing in the second administration really coming to the fray and really being implemented. And to Carmen's point about these executive orders, in the first few months of the second Trump administration, we saw, I think I'm just going to talk about two executive orders. One from March 7th, titled Restoring Public Service Loan Forgiveness, basically threatens to eliminate public service loan forgiveness for organizations engaging in quote unquote aiding and abetting in violations of immigration law. Right. So that's something that could affect me, could affect our partners down in El Paso, where we now go for our service trips. Because these are places that are accused of aiding and abetting immigrants simply for pursuing their international right, their humanitarian right to seek refuge from real persecution in their home countries, right? And the flood the zone is not only the enforcement that we see on our streets, it is the attack on us as practitioners to make our work as impossible as it can be to, frankly, I think, discourage us to even continue the fight. And there was another executive order titled Preventing Abuses of the Legal System and Federal Courts that, just if you look it up and you read some of the language, it's just frankly so hypocritical, accusing, again, repeating this idea that immigration attorneys supported by big law pro bono practices coach clients to conceal their past or lie about their circumstances. That is framed in such a negative way, but I would say that anyone who's in a legal process is going to litigate to the best of their ability, right? I always sort of analogize this to especially folks like Trump who take advantage of the law for their benefit. How is your right to seek asylum, which the statute, by the way, says, irrespective of manner of entry, someone has the right to seek asylum? How is that any different than a tax loophole that allows you to pay very little in taxes, right? And so this weaponization of our own rights is, I think, a very fundamental part of how this assault is affecting us. Talking about how the government is forced or is put under great burden to try to respond to these claims that are filed seeking asylum. All of that, I think, is totally inaccurate when it is the asylum seeker who has the burden of proof, right? And I have my own timer going, so by my count, I have about a minute and a half, so I don't want to belabor this too long. But I want to bring it back again to this idea that, we are seeing not just the federal government, but Texas is another great example. So one of our partners in El Paso, Las Americas Immigrant Advocacy Center, even before the before the Trump administration, they were being investigated. And the Texas Attorney General, Ken Paxton, essentially demanded that Las Americas turn over the records of their own clients under this parole program that was created under Biden, a program that would allow an orderly and vetted process for people from Cuba, Haiti, Nicaragua, and Venezuela to enter the country because they had some other sponsors here in the United States. We all know why they want those records, right? They want to have access to people's personal information and go after them, as we see that they're going after them now. Thankfully, Las Americas is litigating that action. But, all of this puts a tremendous strain on the providers. I've seen it in the clinics that we carry out through the Feerick Center's Immigrant Justice Project, through some partners, including her Migrant Hub. This new practice by the government to file motions to quote unquote pre-terminate asylum claims under the argument that there are these third country agreements puts a tremendous burden on pro se litigants, people without attorneys. I have people coming in through these clinic doors that were given 10 days, the minimal amount of time in order to respond to this motion, which is a preponderance of the evidence standard of proof, which is pretty difficult to achieve even with an attorney. And having just 10 days to do that without an attorney and being told by the immigration judge that all you have to do is write a letter is disingenuous, to put it lightly, right? And so what this does for us is that it forces us to scramble, to have to pivot and meet so many different and competing needs. And frankly, this model is unfortunately not sustainable because for every person that we are able to help, there are 50, if not more, other people who don't have the opportunity to present any kind of response in their claims. And so I was very saddened, but this is, I think, a fair assessment to hear from our partners down in El Paso that what we are doing in these pro se limited scope efforts is akin to offering palliative care in the legal sense, right? Because these people's claims for asylum and protection, though viable, are unfortunately being so overburdened and the system to provide assistance to them so overtaxed that we're forced into this position to offer a reality check about what awaits them: prolonged detention, as we've heard, awful conditions in confinement, and a very long battle that unfortunately most people will opt to seek a voluntary departure back to their home countries, even if that means risking very real harm. In terms of like the academic sort of perspective on this, I'll just, this is certainly speaking from my still, I think, burgeoning career early on out of law school. But And I love that we're having this conversation in this interdisciplinary setting, because I think that the values, especially here at Fordham, with this Jesuit education of cura personalis, right, care for the whole person, is very instructive here, because this assault is having an effect not just on us practitioners, but of course for the community that we serve. The stress and the anguish that I hear from people who are being asked to go to court and see masked ICE agents open up, in front of them as the elevators open up, is very real. And the model that we have going right now in partnership with her Migrant Hub, I think, is fantastic, because they are providing, Marciana and her team of students are providing the peer support, the mental health support, that already was a lot to ask of people in this asylum process, right? Because you're asking people to talk about the worst things that happened to them in this process, in order to present a strong case. And now on top of that, you add all of these additional concerns, right? So I think if there's one thing that we think about, is how we can bring together all of our different expertise, right? All of our lived experience, some of us as non-citizens and allies of the immigrant community, in order to really provide that care for the whole person, because that is what we need, and we do need to continue this fight. Because if anything, it's going to be to document what happened during this time in our history, and be able to tell the truth of this story into the future. I also want to sort of just acknowledge very briefly that we continue to see some concerning developments in terms of well, let me just tell you, if you weren't aware yet, but Texas Supreme Court recently issued a decision where it allowed the state to break off from the American Bar Association. And right now, the American Bar Association is the entity that accredits law schools nationally. And so this decision is concerning for a number of reasons, but essentially now it's going to be the Supreme Court of Texas that's going to say which law schools in Texas are the ones that can be licensed and instruct and educate future generations of lawyers. There are questions about whether that creates a two-tier system and the portability of a Texas attorney's license into practicing in other states. But I think the true concern is where all these detention centers, right? The staging grounds for deportation, where a lot of these cases being heard. We already see some of this with judge advocates general being appointed as immigration judges under this administration without much of any training. And Carmen is probably the best person to talk about that, right? But what we're seeing, the writing on the wall, is the creation of this system that is really a farce, right? It's really just trying to turn out deportations with judges who don't know the law. And unfortunately, I fear soon to be attorneys that might not know the law either in Texas. And other states are listening, watching, and taking their cues from that. So I'll leave it at that for now. But I do, again, want to encourage this idea that this interdisciplinary discussion that we're having right now is very key in order to support and sustain our work.
Thank you, Emerson. Thank you very much for that. So last but certainly not least, I'm going to turn it over to Nirka Melendez to speak in particular about people who are actually caught up in this system and are experiencing this. And most of the folks that she works with are from Venezuela, and I think probably everybody in this room knows some of the specific things that have been going on, both with Venezuelans in this country. I mean, Carmen talked about detention conditions. We look at the Venezuelans who were deported to CICAT in El Salvador, and then certainly what's going on in Venezuela now. So I'm absolutely delighted to hear from you, Nirka, please.
Thank you. Just double check. Gracias. Thank you. Just double check. 10 minutes, right?
Yeah, but she's going to hold up a big sign telling you when you have a minute left.
I won't get that thing. Trust me. I'm so grateful to have this panel. I mean, sharing this panel with these people and having even Carmen saying stuff that I said I couldn't say it better. And I was so grateful to feel that endorsed, even though she didn't. She doesn't know what I'm gonna say, but yet it was like, oh my God, from a lawyer. Oh my God, from a judge. Thank you. My name is Niurka Melendez, and I'm going to take this chance to say thank you and look at your eyes. I usually get really passionate about this topic because it's so personal to me. And I wrote down some words in order to keep within the time and be focused, Niurka, and try to get to the point. It's a cultural stuff, don't judge me. And then it's a personal life experience, don't judge me, please. So thank you. Thank you, Fordham University. Thank you, Marcia, because Marcia has always included the grassroots community insights and thoughts, and we are always grateful for that. And also thank you to the organizers to, again, consider grassroots community organizations to be a part of such a panel. So as I say, my name is Niurka Melendez. I'm a former asylum seeker that after 9 years waiting for her first asylum interview, got finally his asylum a year ago, thanks to co-counsel and their pro bono services. That leads me to one of the passion topic that I always have to be focused. I'm gonna read it. I'm gonna do it. Trust me, but yet that after 8 years being self-educated about being prepared for that interview, I got a pro bono lawyer through co-counsel and Rebecca Press at this extraordinary organization. This is a reality also that we must be mindful about, because even though we know there are many organizations that offer legal pro bono counseling and representation, yet get that could be a lottery. That is something that is not new. It has been like that for decades, I guess. So starting with my reading. So as I said before, my name is Niurka Melendez. My organization is named Venezuelans and Immigrants Aid, VIA. We are a grassroots community-based organization working directly with migrants and asylum seekers in New York City. Nowadays, and after the COVID, we expanded our reach by Zooming and doing another online activities that help us reach people, not just in New York, but other states in the United States, and also people that are on their way towards the US that are, taking advantage of these online events that we also offer to migrants. People that we serve are basically forced migrants. Our focus are forced migrants, and that are navigating the displacement, understanding first what that means, and then the uncertainty and the system that is never, and thanks Carmen that said it very clearly, never designed with their humanity at the center. Most of what we do at VIA is very simple. It is a community, it is information, reliable information, it is an accompaniment, peer support, and it's sitting with someone, as simple as that. Sitting with someone that don't understand what that letter means, could be a barrier of the language barrier, or could be also a mental health trauma that blocked me to even make the effort to understand what is happening there. None of these acts we consider are radical, and yet this act of care, from our view, can be targeted and even treated as a suspicious by this government, and even worse, from our view, underestimated within the ecosystem of nonprofit organizations in the US. That is what we mean when we talk about criminalization of compassion. There is a narrative that we need to slow down and examine. We often talk about migration as a choice and asylum as the ultimate right. But from where we stand on the ground every single day, we see something else that is totally different. Most people do not want to leave their home. They are forced to migrate. And that brings me to the belief that guides my work and my advocacy. The most fundamental human rights is not the right to seek asylum. It is the right to not have to flee your homeland in the first place. Forced migration is not accidental. It is the result of political, economic, and humanitarian failures. I'm saying this from my short experience of living my country, being 44 years old, and having to normalize for almost 3 decades the situation that brings me here and became a refugee. So with that said, the case of normalized even by the international community that sometimes focus on demanding countries to open their borders instead of focusing on what is happening in those countries that are expelling their own citizens. When asylum approval rates remains painfully low, and Carmen said it so nicely, for decades across administrations, that tell us something important. This is not about who is the president. It is about the absence of political will to create human, functional migration systems. And while policies remain the same, we, the community, pay the prices. Families live in limbo. Children go without any stability or certainty. Entire community are asked to prove. We have to prove ourselves one and again and again and again. And sometimes that reminds us our own trauma, and we got tired. At VIA, we witness the gap between what the law promises, what even politicians promise, and what people actually experience. May I go out a little bit from my prompt? If I can tell you, if you ask me about how many people came to me after the past administration promising giving residency to more than 11 million people telling us, you know what, I won't apply for asylum because they will give me residence, you will get surprised. Rights that exist on paper collapse in practice, where there is no access, no counsel, no language support, no trust. At VIA, we also see how increasingly the legal system is even for people who might qualify for protection. Forms are so complex, information is inconsistent, language is a barrier, and the emotional toll of not understanding what is happening to your own case is just enormous. Confusion becomes anxiety. Anxiety becomes fear. Fear becomes silence. Silence sometimes becomes even not to move and losing my deadline. I need to breathe. This is so personal. In that vacuum, I cannot forget about mentioning misinformation spreading so quickly within the community. And sometimes that misinformation comes from the media. People receiving advices from everywhere, WhatsApp messaging, rumors, well-meaning strangers, oftentimes and very oftentimes from people that have been living here for years on the case and tell you, you know what, that's okay. You don't need to do that because when I came here 30 years ago, I never done anything, and here I am, 3 houses, 3 cars, I don't know how much money in my bank. That's not right. That's not okay. We have to be also mindful about that. This misinformation doesn't just confuse people. It shapes decisions made in fear. We have to be mindful about that. Grassroots community organization exists in part to interrupt that fear with accurate information and human connection. This is why I want to be clear about something else. Grassroots community-based organization, and especially VIA, which is a volunteer-based community organization, is not just observers on this system. We are living inside the consequence. Our expertise doesn't come from reports or press statements. It comes from daily actions, from showing up consistently, coherence, and always day, and from being accountable to the people most affected. Trust is built through presence, not rhetoric. Is that a statement that Hector, my husband, and the other co-director of VIA ensures me, Nurka, please say this. And yet too often grassroots organizations are consulted last, even though we got so many, oh my God, how amazed your work is. We are always probably too small to be consulted or too small to be considered to get the support. If we were serious about uploading human rights as the rule of law, then we must trust the knowledge that is produced on the front lines, not just in conference rooms or court fillings. Compassion should not be required bravery. It should never require risking criminalization. Helping someone survive should not put you at risk. Accompanying a neighbor should not make you suspect. Humanity should never be something we have to defend. I want to closing with that invitation rather than a conclusion. If you are a student, please consider include or in your education that touch with the reality is necessary. Talk to people, not from your fears, but being open to just hear sometimes something that we are not expected to hear. There is always room for you, students, to work with us and with anybody else that you are feel connected with. If you are a professor or a researcher, partner with community organization, not just for a specific subject, but as a co-creator of knowledge. If you are a non-profit organization with legal services or policy settings, let's move beyond words. Forced migration is really complex. We are here to give you some examples. Our responses must be integrated, supported, and grounded. At VIA, we believe dignity is not a favor. Solidarity is not a favor. Humanity is not a favor. It is a right. And protecting it means centering humanity over politics, systems over personalities, and lived experience over assumptions. Thank you so very much for listening. I'm really open to your questions.
Thank you, Nirka. Thank you all so much. Yeah, okay. So I know we're running a little over and we promise we're going to give people a break. I'm just checking with a couple of questions from the audience. Okay, I have some questions, but I want to, before, I'm not going to monopolize this time. If people in the audience have any questions for our panelists, we can take one or two and then we promise we will give you a break. Anybody? Yes. Is there a microphone? Or you can come up. Go for it. Yeah. Yeah, that's a great question. Is there anybody who would like to address that?
I mean, I'll take a little crack at part of it because you have a lot that you just put out there. But I was thinking, about, data security, for example, and case notes and having all those files. And you don't want anyone to feel like they can't do the work that they're supposed to do in taking notes and recording things. I would just say that in New York, I think we're blessed by a very vigorous attorney general, just to say, who has come in, at all different levels and all different areas to protect data, and many other things. So, I think people are thinking deeply about those issues for, medical professionals, psychologists, social workers. And I think, we haven't seen it happen. I don't feel like in New York State, as opposed to being in Texas. It's not to say that these things couldn't happen, but they're going to happen through, you can't, they're not going to come in, I'm going to say, you're going to be able to have a moment where you can make a call to the right people to make sure that they know what's happening. I mean, I guess it's just to say that, we don't want to be inhibited, but in doing our work, and catastrophizing, even though there's a lot to be worried about, in this world that we're living in. But I guess it's just to sort of say, having come from government and in fact, the Attorney General's office at one point, that people are being very, very mindful about this on high. And maybe a good thing to do is to link up some organizations that are interested in hearing more about this with the Attorney General's office. And I think those pathways are very viable.
If I can just add to that, because I, for whatever reason, not the least of which is that I don't prepare for my speaking engagements, and maybe because I come from a family of people who stood up in the face of fascism and said categorically not, and were forced to flee their country as a result. I look at what's happening and go, I have tremendous privilege, but for the grace of God go I. And I know what the risk is in what we're doing, right? I know because I was told very directly, you lost your job, keep your mouth shut. Because there's litigation ongoing. Many of my colleagues have refused to make public statements. Many of my colleagues here on the bench in New York will not admit that they were fired because for them, I mean, their careers matter. And my career matters to me, don't get me wrong. But there before the grace of God go I. And if I don't stand up and be counted in, I don't take a risk. And trust me, ICE has made it very clear to me that I am at risk of denaturalization. But I am a lucky one. They'll deport me to Spain. Oh, woe is me. Right? But my clients, they get deported to South Sudan and they die. And I don't see why I should be privileged by my ability to be silent where other people's bodies are on the line. We've never won any fights in this country where people's lives were not put at risk. I think about, what was his name? I know very little about history, but I think about John Lewis, that's his name. I think about John Lewis because I went to work for the Biden administration at a place called the Stewart Detention Facility, which if you don't know about, you should Google, because that place has been hell for long before this administration, under Obama as well as under Clinton. And that place, I chose to go to work there because even in the best of administrations, it had a 97% denial of asylum. And I wanted to understand how the heck intelligent people applying the same law that I applied every day could reach such different conclusions. And what I found were people who had been silenced by history and had been inculcated with the idea that they needed to keep their heads down and they needed to make decisions in a particular way. But that, in part, is because in the South, you saw very recently, like in the 1960s, people being killed for standing up for their colleagues and their friends who were being oppressed. And so it's very recent still, this idea that your life is very much on the line if you get up and stand up and speak out. And now we're being told that all of us need to be worried like that. That if you want to get involved in this fight, that, hey, it's not about you, it's about the immigrants. So if you're a citizen, you don't need to get involved. And if you get involved, then you deserve everything that you get. And at the risk of being naive, I'm not a New Yorker because I keep my head down and I don't speak up. I am a New Yorker first, and I'm an American second. And New Yorkers, stand up.
Yeah, Emerson said that he can't hear.
Oh.
So, no, that's okay.
Sorry, but
His teams are texting him the
I
question.
got people. Yes.
And I think Oh, we can hear now. Oh,
Yes. Well, I'm sorry. There might be an internet lag, so apologies for that. But I did just want to respond briefly to the question. I do have somebody texting me the questions. On a very practical level, for providers, there are resources out there, very basic things you can do to protect your identities and your data. I want to acknowledge that the use of technologies and surveillance by the government for immigration enforcement is deeply troubling. The Feerick Center is working on putting together a program on this precise issue. So please sign up for our newsletters if you haven't already. And I guess just to give one example, there are devices, and I'm not a technologian, but I understand that there are devices called stingrays that can sort of trick people's phones into connecting to their devices to, believing that they are cell phone antennas, and that could risk stealing data. I am looking to drop certain corporations that have contracts with the government, and I have learned of alternate cell phone providers that do things like change your cell phone identifier every 24 hours. So there are alternatives out there. So look out for the program that we're putting together sometime in April, I believe it would be.
okay, we're going to use the microphone for the next question. I think your hand was up next. And then I'm told one more
So
question.
we may not be able to answer the question, but I'm just really curious about anyone in the room who might be engaged in thinking about these things through an international human rights law lens. A colleague of mine just recently published a piece in the Connecticut Mirror on extrajudicial killings, and we need to reframe what's happening in terms of fear mongering and trying to get people to be quiet. And he also is a specialist around the Convention Against Torture. And I just really wonder if we're starting to look and try to use avenues, even if we can't get the rapporteurs to us when we invite them, if we're trying to use avenues to begin really systematically gathering evidence and looking to combat impunity in the long run.
Mm-hmm. I can speak about the few efforts I kind of know about. I know that some of us that were fired from the bench and were willing to speak publicly filed a formal complaint with the UN to report on kind of the silencing of different legal perspectives and the kind of elimination of due process in the legal system. What due process there is, which arguably is under the Fifth Amendment for those of you that are, and we can discuss, and I understand no court has formally said that, we lawyers, this lawyerly aside for the general audience, that, kind of the elimination of what due process is meant to be. And that complaint was filed with the rapporteur. It was University of Chicago Law School worked on that. And then right now, Pace Law School and I believe Seton Hall are working on providing research for UNHCR rapporteurs on, we're working on the detention aspect of it, kind of mapping out the history of detention in the United States, the expansion of detention in the United States, and civil detention specifically, and the kind of the deaths in detention and detention conditions. And that is we're working with one rapporteur here in the United States and one in Italy, and they'll be using that to file a formal complaint. So there's certainly people working on that. Those are the only few little aspects of this that I know about. And it's kind of as someone who has used the Convention Against Torture and international agreements to argue on behalf of my clients having rights protected in the United States that were being abused by their home governments, I know that even thinking in that way with that lens is anathema to me, because we are not the place. We're the place that helped to write those laws to protect others. The idea that we now are people that need to have it here reminds me of Venezuela, where when I was a child, my family migrated to Venezuela because it was a place of economic opportunity that welcomed strangers. And then there was a political shift. And the country that welcomed all others now is in a position where it needs help. And we are turning our back because they're different from us. We wouldn't have said that in the 1980s when they were the economic engine of Latin America. So I think it's an interesting, I mean, you bring up a really interesting point. We're at a period of shift, and maybe it's time for us to recognize that we are not as exceptional as we thought we were.
And meanwhile, the Board of Immigration Appeals has issued a number of decisions restricting access to Convention Against Torture. We have time for one more question, and I see a hand right there. You're going to get a microphone in a second.
Hello. So I currently work with, recent immigrants, and I've been in this work since about 2024. And during that time, we were able to present multiple Know Your Rights workshops. And at that time, it was helpful and effective. But now that we're in a time where your rights are continuously being violated, how would you suggest that we present these Know Your Rights workshops and facts for them when they genuinely do not care to uphold or abide by our rights?
Did you want to?
I don't want to give any advice, legal advice, because we are not a lawyer, but it's as easy as just ask people to check official sources. We have to hold that tie no matter what we hear on media and different media channels. Yet I prefer to keep trusting in the institution and the independence of the institution. So I rely on USCIS website, the Department of Justice website, the Federal Register website in the case of new rules that I have that people said, I heard on Telemundo, madre mía. Honey, did you check the Federal Register, for instance, for this kind of formalized an statement? And again, reliable sources, and always to keep under the law, sources that are related to immigration matters. And then it's something that we apply for our workshops, virtual and in person, is just narrow your sources. I know that can be 1,000 of nonprofit organization, people willing to help, but sometimes we need to narrow that. Who I trust to, who has been more consistent, who has matched what I hear and what is actually happening. And then after that, also use those resources as a source for you. Otherwise, it's going to be, a lot of information that sometimes lead us to misinformation, misleading, and many really frequently lead us to fear. And when we feel fears, we, for sure, any way or other, we will put those fears into our narrative, and that doesn't help at all to our community. So that is the practice that we do. Yes, that's just to say that out loud, sorry.
And if I could just add a little bit to that, sorry, because I will have to hop in a little bit. To the person who asked the question, I also encourage you to come sign up and volunteer with the Feerick Center, because we host periodic clinics, including with our Migrant Hub, where we have, I think, a model that's working. We accept questions from the group members. We also try to give updates on a bi-weekly basis. And I desperately need help to help carry out some of this Know Your Rights presentations work. So visit us at tinyurl.com/IJP volunteer.
Can I say one more thing? So I've been in this for a long time. And for a long time, we relied on Know Your Rights presentations. And I was a big believer. Like, I got on weekends and I'd do this. I was like, know your rights, know your rights, know your rights. And then someone sat me down during the Trump administration. And it was someone who I worked with who was undocumented. And she looked at me and she said, have you ever thought of the hubris of you telling me that I have rights, that I have to defend by myself? I have to stand up to authority by myself and defend my rights. You tell me that those are my rights, but who makes sure that those are my rights, and who's standing beside me to enforce them? And that, I think, it silenced me for a long time. And I've been chewing on that for a long time. To the degree that we learn our rights to defend the rights of others, I think those are the most valuable rights that we can teach. Because we're at a time when this administration will beat and deport immigrants for speaking out and trying to protect their rights. I have students who I cannot allow to practice immigration law because their immigration status is at risk. If the government is upset with them, they face deportation. It doesn't matter what their current status is, they're not citizens. For those of us that have the privilege and ongoing responsibility of citizenship, let us learn what our rights are. And amongst those rights are the rights to exercise our compassion and our responsibility for our community members. Let our bodies be placed between us and violence that is coming upon immigrant communities, because as we've learned over the last month, as much as we wish we were living in a different America, it is only when the bodies of citizens are on the line, and as white bodies of white citizens are on the line, that America wakes up and questions whether what is being done to immigrants is right. And I hate to be the one to say this, but it's time.
I said one more question. That was true, but we do have a comment from one of our audience members. If you could just identify yourself, please, and I think you wanted to respond to, and you got a microphone right there.
Hi, my name is Amadou Ly. I'm the founder of the Amadou Ly Foundation. I'm originally from Senegal. I'm a Senegalese American. I want to talk about some of the solutions, right? Because the knowing your rights solution it's an amazing solution. But within our foundation, what we've been doing is utilizing habeas petition, all right? And I'm looking at 69,000 people in detention right now. However, over the past few months, when we started getting the grip of habeas, we've been able to secure the release of many people, right? So my thing is this: we're in New York, right? And we have a lot of judges, but we're in a democratic state. It is time to play the game, which is let us focus on habeas petitions, because what it does is it tells the judge, well, look at it and see if the arrest was lawful. But this is not an immigration judge who's gonna make this decision. Right? So I believe that organizations should start shifting the focus and make sure that whoever is arrested, make sure that people are aware of their rights within having habeas petition filled out for them, right? Because then judges, we give the opportunities to real judges to actually determine whether those arrests were lawful or not. Therefore, I'm encouraging everyone, because in our foundation, the Amadou Ly Foundation, that's what we've been doing, and we've been able to secure Canal Street. We secure the release of many of them because of that, right? And it's easy, it's not as complicated to learn. So that's what I wanted to share with everyone. Thank you so much.
Thank you. Really, really appreciate it. Okay. With that, we are in fact done. Please join me again in thanking the panelists for being here today.